The Orlando shooter dead, but his wife still with us. The question is, if she knew what he was planning to do but didn't tell police, could and should she be charged? Well, that's what a grand jury is deciding as we speak. Our panel of attorneys here to hash it out. Then the Orlando shooting is once again flaring a debate about the Second Amendment. We're going to tell you about the gun case that could go all the way to the Supreme Court and possibly be a game changer for gun control. And also, who else but Donald Trump? Well, he keeps hammering away at Hillary Clinton for destroying some of her emails, but the question is, did the Donald do the same thing during one of the thousands of lawsuits he's involved in? Evening, everyone, and welcome to RFL. I'm Richard French. Thank you so much for joining us. Well, the wife of the shooter who killed 49 people in Orlando could be facing charges very soon. She is speaking to the FBI, and a federal grand jury has been convened.
Investigators now focusing on Noor Salman, Orlando shooter Omar Mateen's wife, asking what she might have known about her husband's plans. Salman now cooperating with the FBI after being shown footage of herself with Mateen at various Orlando locations. Law enforcement says she allegedly went with her husband to buy ammo, and they had been to Pulse nightclub together at least once. It is not clear whether she knew his plans for mass murder or had been questioned by the FBI on terror ties. Also unknown to the man who sold Mateen his weapons.
Would you have liked to have known that the FBI was investigating him for terrorism?
It would have been fantastic. He wouldn't have gotten a gun.
All right, a lot to unpack here. Let's bring in our legal panel. Jim Koutsouras, Jimmy's criminal defense attorney in Manhattan, who sits on the board of directors of the New York City Criminal Bar Association, frequently lecturing at New York Law School and the bar associations in Queens and New York City, as well as former prosecutor. Doug Von Oist, a founding partner of Carson Von Oist, focusing on corporate misconduct, selected by the Legal 500 as one of the most influential trial lawyers in the country. He also a former prosecutor. Bill Aronwald, a defense attorney, former assistant U.S. attorney. And to his right, Mayo Bartlett, an attorney at the law offices of Mayo Bartlett PLC and a former chief of the Bias Crimes Unit at the Westchester County DA's office. And Mark Furnish, professor at Brooklyn Law, as well as a practicing attorney, has also argued before the U.S. Supreme Court. Gentlemen, thank you all. All right. This much we all agree on, complete tragedy, with a lot of questions at this point as to where we move forward as a nation post-Orlando. But one of the questions immediately before the folks in Orlando, I'll start with you, Bill, is whether or not to get an indictment and then maybe down the road a conviction against the wife of the now deceased shooter. This much we seem to know from her being a cooperating witness with the feds, which is she had been with him on more than one occasion, we believe. She knew that he had not only procured, but had been heavily invested in recent weeks in inflammatory rhetoric, terroristic rhetoric, and she had known that he had talked openly about attacking and doing some terroristic act against one of these gay bars. She also knew that he had the means and the material with weapons as well, and had gone with him as he'd purchased ammos and I believe weapons in the past. Is that enough, pardon the pun, of a loaded gun here to say that you're not just a cooperating witness, but you yourself should be liking an indictment for cooperation?
No, that's the short answer. Aiding and abetting is a separate crime, and in order for someone to be convicted of aiding and abetting, there has to be some evidence to indicate that they were knowingly and willfully and purposely acting as the agent for the principal, and in this case, her husband. Mere presence at the scene, the fact that she accompanied him to gun stores to buy ammunition, the fact that she may have gone with him when he went to look at the club Pulse, even if she had heard him talk about inflammatory comments about gays or about blacks or anything like that, that doesn't rise to the level necessary to be able to sustain a charge of aiding and abetting. What you need to be able to do is you need to be able to prove beyond a reasonable doubt that the person associated with the criminal venture, which means that the defendant shared the criminal intent of the principal. This element cannot be established if the defendant had no knowledge of the principal's criminal venture. And secondly, to participate in the criminal venture. And what that means is that the defendant engaged in some affirmative conduct designed to aid the venture or assist the principal in the crime. A classic example would be if, for example, there was evidence that she drove with him to the club and that when he went inside, she stayed in the car with the motor running. That would rise to a different level. But on what we know now, and we don't know everything because we don't know what she's told the authorities, but on the basis of what we know now from what you just told me, I would say that they would not be able to sustain the charge, and she should not be indicted for aiding and abetting.
Okay, but Mark, let me ask you let's say there is no material evidence that she ever was involved in the planning of the attack. However, we do know that she reportedly had gone with him on one occasion to Pulse. We do believe, at least from what we heard from sources, that she's already told the feds that she's been pretty clear that he was going to be targeting a gay club or whatever with some terroristic intent. Where does it start and stop in terms of her responsibility to pick up the phone and say, hey, law enforcement, this is a loaded weapon waiting to go off here. Right. I don't know exactly when, but this is what he said so far. Is it enough to say, well, you know what, he never gave me the exact time here, so therefore I don't have a responsibility?
It's the classic question from Watergate, right? What did she know? When did she know it? What, if anything, did she do to help it? Bill's right, based on the facts as you outlined them, and of course we don't know all the facts, it wouldn't rise, as you outlined it, to aiding and abetting liability, but there's a separate offense in the U.S. Code called misprison of felony. And if she had knowledge that this went beyond mere chatter and he was actually staking out the place and he was pretty close to doing it, then she has a duty to pick up the phone and call the right person to try to thwart it.
Even if she doesn't know that he's going to do it on a Saturday night.
Look, that's the fact question, and that's what would make it hard to prove, and that's a federal felony punishable by up to 3 years. If it goes beyond mere preparation to something that's seems like it's going to be carried out pretty soon, she's supposed to pick up the phone and call. Now, we hear coming in today that it doesn't appear likely that she's going to get charged. They could make a charge of virtually anything. Whether it will stick or not is a different question. They probably wanted her to cooperation to see if he's affiliated with anybody else who he's been in communication with, et cetera, et cetera. And from what I gather, they put she lied first to the FBI, so that's right. A separate crime, 1001 violation, a false statement. Then they put pressure on her and she started to talk more. And they probably said, if you tell us, we won't charge you with misprison or
Remember,
anything else.
She's the source and the only source of the information that they can use against her, at least right now. I mean, whether or not they can corroborate or not is different, but Mark is right. If she knows that he's targeting a gay establishment and she knows he has weaponry and she goes with him to buy the ammunition, then at least those facts tend to a conclusion that she knew that he was going to do something.
He's not allowed to buy weapons. I doubt that he's a licensed.
No, he was.
Oh, he was.
The other thing, going to Jim's point, I mean, the fact that she went with him, if the law is quite clear that the mere presence is not enough. The fact that she may have gone with him to buy ammunition, I mean, according to the gun shop owner, he was a regular target shooter. I mean, this was his avocation. So I don't think that really gets her anywhere
But Bill,
closer.
that's what I mean. The information's coming from her, and if she slips up and says, I knew he was going to do something like this, and that's why he went to buy the ammunition on that day.
The guy also is a licensed security officer, so he has a legitimate reason to buy weapons and to have ammunition.
But Mayor, when it gets to he's taking, in this specific case, and maybe the facts are too granular here, but he's going to a gay bar, and he's bringing his wife, and he's spoken with non-debatable hatred towards this population, and he says he wants to bring harm to them. The broader point is, we are always told to see something, say something, okay? And now I'm getting into the sloganeering, maybe not the law. But clearly, the feds want to make a point here that if you know anything, we not only want you to say something, but you face criminal exposure if you sit on it.
I don't think the feds really even want that to happen because it's not practical. And what happens is every time somebody gets frustrated or upset and says, I hate these people, I want to kill these people, even though they're never going to act on it, that would trigger the feds being overwhelmed with tips that somebody said something in the heat of the moment at a boxing match or a soccer match. So what will happen is it's got to be more than the person actually says it. You have to see if they say they're on there.
But here's where the rub comes into being. I can go through 6 examples, including the Sarnarevs, including obviously what we saw in Orlando, and other examples as well, where these guys were actually under, if not surveillance, they were interviewed, they were questioned, there were people of interest at one point. However, when the feds looked at him, they didn't have enough actual intelligence to either put him on a watch list or keep him on a watch list, let alone to prosecute or to put surveillance on him. So my point comes to, you worked in this, right? Where is that line between, and are we comfortable with that line?
You still
to
wouldn't
saying,
have
go
enough.
ahead,
might.
we'll give you more latitude if they're on, you know, even if you don't find some tangible
Richard,
to keep them on a list.
I think the FBI's response to that was, I mean, Director Comey said this. He said that basically they did have some information. They did look into it. He was on some list for some period of time, but after a while, when they weren't able to develop any other information, he was purged from the list. I mean, you can't just be put on a list because someone makes a claim against you and it's never substantiated, and then that person is on that list in perpetuity forever. It's just not the fair way to do it.
If she had gone forward and contacted the FBI or local law enforcement and said everything she knew, well, they would have interviewed him and they would have found that he had ammunition and that he had guns. That's not enough to charge him. It wouldn't have changed anything.
Well, no, but look, you can't have a blanket per se rule about these cases. They're inherently fact specific. It depends what he did in her presence. If he repeatedly staked out the place, purchased guns, and said, I'm going to use these guns, there's very little doubt that they could charge her with misprision of a felony.
I'm not talking
whether
about her.
it would
I'm
stick.
talking about whether she would have been able to prevent him from doing what he did. It would have been ineffective because no crime had occurred at that
I don't
point.
know if it would have been ineffective.
Nobody could say that would be effective.
Well, it wouldn't have necessarily stopped him from carrying out an offense.
No, but
Not
if
necessarily,
they
but-
step to him, if you know that the authorities are onto you, then that in and of itself sometimes can be
Well, first of
somewhat
all,
of a
you could have been
deterrent
on a
factor.
watch list where you wouldn't have been able to buy an assault
Or it
weapon.
could have
if they were-
triggered a faster response by him.
Let's take a step back and sort of think this through like lawyers. I mean, to Mark's point, basically, you know, if they could prove that she knew, if they could prove that, the fact of the matter is, from everything we know, the only source of evidence they have is her.
Right.
Okay, so how do they prove that she
Well, I don't
knew?
know. There's probably surveillance cameras outside the club that could see if it was being
there's
staked
also
out.
eyewitness
at
accounts
points.
that they saw.
And there's
Mark,
eyewitness.
but
I mean,
Mark,
look, the
that
point
doesn't
is,
prove she knew.
No.
if they see, look, whether they can prove it or not is another story. It's going to be a fact-specific determination whether it was, a jury would decide whether it's idle chatter or mere preparation or something more
If it gets
serious
so
that
far.
occurred.
Rich's
It's not
question
going to
had
go
more-
that
Rich's
far.
question had more about should she have said something? Is she under a duty to say? I
Again,
agree
she
that
has
there
this-
isn't enough
but that's
evidence
why
to
it's
charge
so
her.
hard to convict, because it will depend.
Yep.
She has to make a judgment
and we
call
didn't
if it's
even have
just
time,
talk or
but
what.
we know the prior wife, the ex-wife, she had been abused by this guy, and there was reports at least that maybe this current wife was as well, so fear of safety and everything else. But we'll see if there's an indictment, and then we'll see if there even is one at that case, if they can secure a conviction. Okay, when we come back, one of the common elements of all these tragedies is there's a gun involved, and sometimes an assault weapon. When we come back, an appeals court is taking a second look at the Second Amendment, and its recent ruling could be a major win for gun control. We'll explain the debate after this.